We are in Milan presenting our proposal at the Dispute Resolution Conference on the Globe Rules on Dispute Resolution, a subject which requires attention by the OECD and the Inclusive Framework, and our proposal looks into it in several ways.
Thank you very much, Guglielmo, for the kind invitation in Milan with the colleague. Indeed, our presentation proposal looks at the possibility to solve globe disputes without a multilateral instrument. And that basically proposal is based on three core principles. The first core principle is an enhanced interpretation of Article 25.3 of the OECD model, second sentence, which would be clarified through a subsequent practice confirming the possibility of that provision to deal with globe disputes. That, however, is not the main element of our proposal. The main element of our proposal is the inclusion in the globe model rules of a domestic disputes resolution provision, which would present, in our view, the following advantages. First, as I said, it would crystallize a subsequent practice with respect to the application or the possibility to solve globe disputes. Secondly, and that is a recurrent issue in relation to Article 25.3, it would lift domestic law obstacles. Thirdly, it would also apply to non-treaty cases on a standalone basis and subject to the principle of reciprocity. Our research indicates that, first of all, the application of the principle of reciprocity in international tax relation is widely applied already, in particular in areas of VAT relief or in the area of shipping companies, but more importantly, in relation to some territories, notably the one concluded, the arrangement concluded with Taiwan. The content of a double taxation treaty is included in domestic law, including the MAP procedure, and that provision is applied on the basis, that framework is applied on the basis of the principle of reciprocity. Also, domestic investment laws also include a dispute resolution provision. So the framework, the architecture that we are proposing is not unknown in international relation. Third principle, based on our model, a provision giving priority to the globe model rules in the interpretative exercise. And the purpose of that provision is basically to make sure that once the globe rules are transposed in domestic law, that diverging interpretations are avoided, in particular through the use of different canon of interpretation. So this third element basically would ensure a consistent and harmonious interpretation of the globe model rules. So if we look at briefly the architecture, you see that you have these three elements here, which is basically the enhanced interpretation of Article 25.3, but more importantly, a domestic dispute resolution mechanism, which would be included in the globe model rules and which could also apply on a standalone basis in non-treaty situation on the basis of the principle of reciprocity. And finally, the third element, to which I have just alluded to, which is the general interpretative rule.
A few words on the first principle, namely enhanced interpretation of Article 25.3. The language of Article 25.3 is broad enough to permit the application to issues which go beyond the treaty issues. That is clearly mentioned in the second sentence of Article 25.3 when the provision indicates the consultation between contracting states in order to avoid and resolve issues which go beyond tax treaties. But if we move to the domestic dispute resolution mechanism, then we have the proposal reflected in Article 8.3. You can see on the slide that paragraph 1.831 has remained as drafted in the current version of the model rules, but additional provisions have been added precisely to permit this mirror legislation where domestic rules in parallel permit and create a dispute resolution mechanism. And that is reflected in Article 8.3.2, which precisely reproduces 25.3, but is a domestic provision and not a treaty provision. And also the same rule also applies to non-treaty situations subject to reciprocity, and precisely in Article 8.3.2 of the proposed rule, the dispute resolution mechanism applies also to disputes which are not covered by tax treaties, because the issue of interpretation is an issue related to countries which have not concluded a tax treaty between themselves. We have also additional provision which also reflect Article 25, and particularly the one regarding the communication and interaction between tax authority in the context of the dispute resolution mechanism.
Yes, the dispute resolution provision could not work if there's no legal basis for exchange of information. So we needed to make it effective, a legal basis for that purpose. It's clear that in tax treaty covered situations, the exchange of information provision of tax treaties could work also for the dispute resolution system, even if the dispute resolution system is regulated at the level of domestic law. But there are many cases of non-treaty covered situations, so we needed to find a legal basis for that purposes. And actually we thought that the multilateral mutual assistance Convention of the OECD and the Council of Europe, which covers as many as 146 countries, could also be used in tandem with our provision to provide a legal basis to exchange information in situations that are not covered by tax treaties.
Now, of course, the question is how to prevent our rule from applying, which is what everybody is looking for. The solution that we are offering for the debate is to prevent part, at least, of the disputes by introducing an interpretative rule in the model provisions that are to be transposed in each and every state. The underlying assumption of this proposal is that many of the disputes which are likely to arise are not based on the existence of departures from the model rules, but rather from a difference in interpretation of the model rules. And since the canons of interpretation may not be harmonized globally, we think that the best way to prevent those differences is simply to offer a unique and harmonized rule of interpretation of domestic legislations which transpose the model rules. And the wording of that one would be: the domestic globe rules will be interpreted in the light of the internationally coordinated system of minimum taxation reflected in the globe model rules. You may observe that this is slightly different from what the OECD has already put in the model rules as they stand right now, where the OECD says that the tax administration should, subject to the requirements of domestic law, apply the globe rules in accordance with any agreed administrative guidance. Now, the term apply is to a certain extent ambiguous, and one may wonder whether application includes or does not include interpretation. For the sake of clarity, we think there should be an autonomous interpretative rule. Now, it's true that even though this rule may be inserted in the model rules, this will not solve all problems. There may be problems will still remain because states that have adopted legislation still want to depart from the model rules as they have been established by the OECD and the inclusive framework. If we do have cases of conflicts which arise in a situation when one state applies the model rules properly and the other state departs from the rule, then we have a serious problem, and that's where our rule becomes extremely necessary. One may anticipate that these situations should be residual, because especially of the peer review framework that the OECD intends to put in place, such a peer review system should in theory prevent states from having legislations departing from the model rules, but you never know, and the peer review system will probably not be able to tackle all possible situations. In particular, one can hardly see how the OECD could possibly control the application, the guidelines issued by tax authorities, etc. So we may need our system anyway. Of course, there are some objections that could be raised against our system. We cannot, of course, neglect them. One of the main objections that we currently hear is the idea that it is difficult to reconcile the principle of legality of taxation with the idea that a rule could authorize a tax authority to disregard its own legislation. That's, of course, an objection that has to be taken into account. The way we think we can deal with that objection is to say that the rule that we are contemplating is not a purely procedural rule that would give unlimited powers to tax authorities to do whatever they want. Actually, first of all, it's not an empowerment to do whatever they want. It is an empowerment to come back to the inspiration of the rules that will have been adopted by the states, which, as we remind, are supposed to follow a common approach. And second, it's not only a procedural rule, it's a substantive rule that is in conflict with a more general rule, but the exception rule prevails over the general rule. And our substantive rule, of course, has a procedural consequence, that is, allowing the tax authorities to come back to the model rules when necessary. So this is, for us, a key question, of course, but I think we have strong arguments to deal with the objections that may be raised.
Yes, in practice we have two layers. The first one, where we have substantive rule which permit an adjustment related to diverging rules in other jurisdictions. Then we have a dispute resolution mechanism, which is a procedure which relies on the substantive rule which provide for this mechanism.
Well, one further question is whether we could simplify our provision to actually make it simpler. In our first version of the provision, we leverage on Article 25.3 of tax treaties when the situation is covered by a tax treaty. Whereas if there's no tax treaty, then we have the independent part of our provision that would work together with the multilateral mutual assistance convention. So we thought, can we still take it further and simplify the drafting of our provision in order to simply do not leverage on Article 25.3, which in itself is a difficult provision to apply and has many obstacles in international practice? And the answer is probably yes. We can have a provision in domestic law that picks up all the elements of Article 25 of the OECD model without actually referring to Article 25 or to any tax treaty. That provision can be applied in tandem with the exchange of information provision of tax treaties or in tandem with the MAC. We think that this drafting will be simpler, will avoid to make reference all the time to Article 25.3, and we just have to, or tax authorities can actually simply apply the domestic provision without referring to the mutual agreement procedure in tax treaties.
So, in conclusion, this is our contribution to the debate on the development of this internationally coordinated system, the globe rules, and we hope that we can contribute further following work which will be done in this context.